In this case, the Supreme Court yet again grants emergency relief to Trump when irreparable harm is sorely lacking. The government's sole argument on this score is that the TRO chills its enforcement efforts and deters officers from stopping suspects even when they have reasonable suspicion. Yes, the government being frozen by an unelected black-robed tyrannical inferior district trial court Article 3 judge is suffering harm, irreparable harm. If that judge unlawfully restricts the powers of the Article 2 executive branch for even an instant, that is irreparable harm to the Article 2 executive branch. It's harm that cannot be made up for with money, the very definition of irreparable harm. Let's listen to the lamentations of the crones, Sotomayor, Kagan, and Jackson dissenting. In early June, the government launched immigration enforcement raids across LA and surrounding counties. During the raids, teams of armed and masked agents pulled up to car washes, tow yards, farms, parks, and began seizing individuals on site, often before asking a single question. A federal, an unelected black-robed tyrannical inferior district trial court judge found these raids were part of a pattern of conduct by the government that likely violated the Fourth Amendment. Based on the evidence before it, that court held the government was stopping individuals based solely on 4 factors: their apparent race and ethnicity, whether they spoke Spanish or English with an accent, the type of location, such as a car wash or bus stop, the type of job they appear to work. Concluding that stops based on those 4 factors alone, even when taken together, could not satisfy the Fourth Amendment's requirement of reasonable suspicion, the unelected black-robed tyrannical inferior district trial court judge enjoined the government from continuing its alleged pattern of unlawful mass arrests while it considered whether longer-term relief was appropriate. So she's already being dishonest. She's calling it mass arrests. The legal question here is transient stops. That's what the reasonable suspicion is for. Reasonable suspicion is not for arrests. Arrests require probable cause. Reasonable suspicion is for stops. And then if it turns out the person's illegal, then you have probable cause to make an arrest. So not surprising anybody, right? If progressives didn't have lies to tell, they'd have nothing to say at all. She's already completely conflating the legal issues. Instead of allowing the unelected black-robed tyrannical inferior district trial court to consider these troubling allegations in the normal course, a majority of this Supreme Court decided to take the once extraordinary step of freezing that district court's order. That decision is yet another grave misuse of our emergency docket. We should not have to live in a country where the government can seize anyone who looks Latino. By seize, of course, what we're talking about here is a very transient stop. Hey, can I ask you a couple questions? That's it. Who looks Latino, speaks Spanish, and appears to work in a low-wage job. Why not? Those are the 90 million illegal migrants your people let into the country. How else are we supposed to identify them except by their defining characteristics? Rather than stand idly by as my diabetes worsens while our constitutional freedoms are lost, I dissent. In early June, the government launched Operation at Large in LA, deploying roving patrols of armed and masked immigration agents. They really don't like the masks. How quickly did that turn around? 4 years ago, it was mandatory masks all the time. Now they don't like the masks. And Carrie, why are we extending our constitutional rights to suspected foreigners? They're getting their rights. This is the due process any of us are entitled to for a transient stop by law enforcement. Reasonable suspicion. Literally nothing wrong is happening here. Armed, they don't like these officers being armed, and they don't like them being masked, even though these officers are getting death threats, assassination threats to themselves and their families. To local car washes, home deports, tow yards, bus stops, farms, recycling centers, churches and parks. Yeah, everywhere. Everywhere illegals might be, that's where we need to go. And let's prioritize the places they are most likely to be. Over the course of the next month, the government made nearly 2,800 immigration-related arrests and detained many more. So they were detained without an arrest? A far larger number? That's what reasonable suspicion is for. For instance, on June 9th, immigration agents arrived at a tow yard in Montebello, Oh my God, they were carrying handguns. Law enforcement officers were carrying handguns and military-style rifles. Oh no. Jason Gavidia, a Latino U.S. citizen, was working on his car in the tow yard that day. A masked agent ordered Gavidia to stop right there and began asking him questions. Agents then asked Gavidia whether he is an American. At least 3 times. 3 times he said he was. Unsatisfied, the agents asked Gavidia for the name of the hospital in which he was born. And when Gavidia could not immediately recall, the agents racked a rifle, took Gavidia's phone, pushed him up against the metal gated fence, put his hands behind his back, and twisted his arm. Oh no, they twisted his arm. They didn't twist his arm. They released him only after he offered up his real ID. Well, he could have done that immediately. That ID was never returned to him. Oh. Less than 10 miles away in Whittier, immigration agents raided a car wash managed by U.S. citizen Jorge Viramontes. Who says he's a U.S. citizen, by the way? He's probably a birthright citizen of illegal migrant parents. That's not a U.S. citizen. In the 9 days between June 9th and 19th, agents returned 4 times, each instance in the middle of the workday. On one occasion, an agent questioned Viramontes, asking if he is a citizen, asking for his ID. He replied he's a dual U.S. and Mexican citizen. Oh, that's good. How many dual Mexican citizens does America really need? And supplied his California driver's license. The agent said the ID was insufficient, grabbed his arm, escorted him to a vehicle, and drove him to a warehouse area for further questioning. Agents detained him for 20 minutes while they made calls to verify his U.S. citizenship. Just like if they made a traffic stop, folks. Sometimes they take 20 minutes, and examined his Mexican ID before eventually driving him back to work. So we're supposed to believe that it shocks the constitutional conscience to believe that this guy, Viramontes, could be an illegal migrant from Mexico when he's literally a Mexican citizen. That's supposed to shock our conscience. That's crazy. Other Operation at Large encounters have included even more force and even fewer questions. Agents pulled up in 4 unmarked cars to a bus stop in Pasadena. The doors opened. Men in masks with guns started running at 3 Latino men who were having their morning coffee and waiting to be picked up for work. Okay, what's the problem? That was Pasadena. In Glendale, nearly a dozen masked agents with guns jumped out of cars at a Home Depot and began chasing and tackling Latino day laborers without identifying themselves as ICE or police. Anyone ever seen one of these ICE officers without badges, without patches saying ICE, police on his gear? That's identifying themselves as ICE, folks. They didn't shout, "I am ICE," before they asked the question. That's not required. In downtown LA, agents jumped out of a van, rushed up to a tamale vendor, surrounded him, and handled him violently, all without asking any questions. Imagine, it shocks the conscience that a tamale vendor in LA might be reasonably suspected of being an illegal migrant. How outrageous! How outrageous! The operation has sparked panic and fear across LA, especially among the illegal migrant community. Some have likened the detentions to kidnappings. Well, of course, it would take a moron like Sotomayor to characterize a lawful transient detention as a kidnapping. A kidnapping is a crime. A lawful transient detention done with reasonable suspicion is the opposite of a crime. One Latino U.S. citizen, look, it's all going to be about feelings now. He feels like he needs to carry his passport for protection. Well, why not? If you're a Latino U.S. citizen in LA, why would you not carry your passport? I would carry it in a little case around my neck. Unfortunately, it may not be your fault, but unfortunately, the Democrats have allowed 90 million people just like you to illegally enter our country. We are now enforcing immigration law. If you happen to look just like them, you might get stopped for a question or two. Another Latino U.S. citizen, similarly, he doesn't have feelings, but he's worried that as a visibly Latino man, does he do a little dance going down the street? He could be detained if he does not carry his passport, but decided against doing so because he believes that as an American, he should not have to live like that in his own country. So what if someone of the same description just robbed the bank? Would the police responding to the bank robbery with that description, seeing him, would they not be able to make a transient stop Or as an American, does he not have to live like that? Many are struggling to make ends meet because they're afraid to go to work, especially the illegals. Others are reluctant to attend school meetings and pick up their children from work. Again, especially if they're illegals. These people filed this putative class action. What's the class? Is the class every Hispanic American? They're now free of being stopped by the police under the reasonable suspicion standard? Is that the class? The plaintiffs allege the government has violated the Fourth Amendment by adopting a policy, pattern, or practice of stopping individuals without reasonable suspicion. It's so funny. Again, the reasonable suspicion standard being applied by ICE is the same standard law enforcement has always used. Reasonable suspicion, articulable suspicion under the totality of the circumstances. ICE didn't change anything here. There's nothing new here by ICE. The only new thing is that a federal judge decided, well, it's okay to use that standard in every law enforcement environment, unless you're deporting Latino people, unless you're deporting illegal migrant Latinos from LA, then you're not allowed to do it. The plaintiffs then moved for a temporary restraining order based on those factors. This is getting kind of repetitive, so I'm going to skip over some of it in the interest of time. They submitted 21 declarations describing dozens of seizures that occurred throughout the Central District in June and July. Yeah, we got 90 million people to deport. We're busy. What's 21 out of 90 million? That's not a very big fraction. And they submitted statements by federal officers. Oh, look, by federal officials. They love quoting Stephen Miller, reportedly told officers to just go out there and arrest illegal aliens and directed them to target Home Depot and 7-Elevens. Well, I guess that's where you get the Indian illegal migrants, right? Now, first of all, he reportedly said this. Where's the evidence? Where's the evidence? But even if Stephen Miller said this, he's allowed to say anything he likes. The legal question here would be the actual immigration officers. Did they do something unlawful? Not what Stephen Miller might have said somewhere else. What matters is the actual policy employed by the officers. But they hate Stephen Miller. They hate Trump. They love taking these political statements and then pretending that these are like absolutely proven facts in a court of law. Senior immigration officials also told agents to turn the creativity knob up to 11. So now Sotomayor hates creativity, to push the envelope. She hates envelopes. And if it involves handcuffs on the wrist, it's probably worth pursuing. What's wrong with that statement? If you have sufficient fear of harm from the suspect that you're going to cuff him during the detention, well, that's part of the totality of the circumstances, right? What led to that fear? What are those facts? In opposition to the motion for TRO, the government submitted 2 declarations. So now this is supposed to be a battle of the number of declarations. If only you can get a bunch of illegal migrants to submit 10,000 declarations, then I guess the elected Article 2 executive branch president has no power here. Trump only submitted 2 declarations. The illegals submitted 10,000. They win. Imagine that being legal reasoning. One stated that the government's officers are trained to consider the totality of the circumstances to determine reasonable suspicion, and that certain types of businesses, including car washes, have been selected for encounters because past experience demonstrates illegal aliens tend to use and seek work at those locations. This is articulable facts and experience contributing to reasonable suspicion. The district court granted the TRO on July 11th, and it was insane on its face, of course. All kinds of supposed fact-finding by the TRO. There's the TRO. The government appealed to the Ninth Circuit and moved for a stay pending appeal from the Ninth Circuit. I guess the Ninth Circuit denied the appeal, denied the stay. So the Court of Appeals rejected the government's argument and denied the government's stay of the district court rule. Then they began briefing the appeal on the merits, and the government, I guess, moved to the Supreme Court. Yep, the government sought a stay in this court pending further proceedings. So whenever the anti-Trump people want a TRO or a preliminary injunction, it's handed out like candy. But if Trump wants a stay of that TRO or injunction, then suddenly they remember that this is an intrusion into the ordinary process and an extraordinary remedy. Well, that's the standard for the initial TRO and injunction too. TROs and injunctions are supposed to be extraordinary remedies that almost never happen. Have they been rare? in the age of Trump, President 47? The court will not grant a stay of an injunction absent extraordinary circumstances. That's supposed to be the standard for the injunction in the first place. Does it seem to you it's being applied that way? The applicant bears an especially heavy burden. Again, that's the burden that's supposed to be on the person who asked for the injunction in the first place. But they're being handed out by candy by these unelected black-robed tyrannical inferior district trial courts. The government, and now we get to the histrionics, and now the concurrence has all but declared that all Latinos, U.S. citizens or not, who work low-wage jobs are fair game to be seized at any time, taken away from work, and held until they provide proof of their legal status to the agent's satisfaction. That literally has always been the law, the immigration law. Yes, it's technically, constitutionally, it's a seizure if a cop says, hey, can I ask you a couple questions? But she makes it sound like a net was thrown over them. And yes, the law requires that if you're asked by immigration about your immigration status, you have to answer their questions. As the trial court found, well, I don't care about the trial court's findings. We've covered that. The Fourth Amendment imposes limits on search and seizure powers. Yes, and a transient stop is justified with mere reasonable suspicion. Officers may stop an individual only if they are aware of specific articulable facts. By the way, he looks Hispanic. He speaks Spanish with English with a Spanish accent, and he works in a job that's particularly attractive to illegal migrants. Those are all articulable facts, together with rational inferences of those facts that reasonably warrant suspicion that the individual may be, not is, may be illegally in the country. This requires more than an inchoate or unparticularized suspicion or hunch. Right. It requires articulable facts, which these agents are using. Critically, a set of facts cannot constitute reasonable suspicion if it describes a very large, presumably innocent people. So the left wants to say, listen, if we'd only let in 100,000 illegal migrants, that would be a small enough group that we would allow you to use the normal reasonable suspicion standard to make immigration stops. But because we've let in 90 million of them, we're going to take that tool away from you, because now they constitute a very large category of presumably innocent people. The Supreme Court has held that Mexican ancestry alone does not constitute reasonable suspicion for a stop. Yeah, but of course, ICE is not saying they're using that alone. The Supreme Court has said that standing in an alley in a neighborhood frequented by drug users did not arise to reasonable suspicion by itself. Right. You need a totality of the circumstances. The Fourth Amendment thus prohibits exactly what the government is attempting to do here. No, it doesn't. Seize individuals based solely on a set of facts that describe a very large category of presumably innocent people. As a district court, the unelected black-robed tyrannical inferior district court currently held, the four factors, apparent race or ethnicity, speaking Spanish or English with an accent, location and type of work, are no more indicative of illegal presence in the country than of legal presence. Yeah, they are. They are, because there's a concentration of illegal migrants with these characteristics. If there weren't, you think if ICE was going to places they were not likely to find illegal migrants, that the left would care? The only reason they're having a fit about this, the only reason this unelected black-robed tyrannical inferior district trial court judge issued this injunction is because it's working. It's working. This, in fact, is where the illegal migrants are. The government, joined by the concurrence, brushes aside this court's precedent with an appeal to probability. Okay, what's wrong with that? Arguing that the high prevalence of undocumented immigrants in the Central District should enable agents to stop a relatively broad range of individuals. Yeah, you brought 90 million of them in, and there's a lot of them here. You could throw a stick in LA. Throw a tennis ball down the street in LA. It's going to bounce off an illegal migrant. You did that. And keep in mind what's happening here. It's just a transient stop. That's all. It's 10 minutes, 20 minutes at the most. That's the longest term temporary detention they were able to cite. 20 minutes. I've had traffic stops that were more than 20 minutes. Although in fairness, that cop was being a bit of a dick. It didn't have to take 20 minutes.